business channels. We listen, we tell, we inspire. Business
So I was asked to discuss the legal implication of the permits to campaign and to win in relation to Anti-Terrorism Act of 2020, or otherwise known as RA 11479. So these are my flow of presentation. First is the legal implication. Second, the updates about RA 11479 or ATA of 2020, the press release of Ntfl CAC, and the salient features of ATA 2020. So, pupunta ko na po agad sa legal implication. Of course, dalawa lang po ang legal implication niya, ng permits to win and campaign sa RA 11479. First, all those who patronize and subscribe to it or who patronize or subscribe to permits to win and campaign will be penalized under RA 11479 or ATA of 2020, and all those who commit and issue the permits to campaign and win will also be penalized based on RA 11479. So, take note of that, dalawang legal implications. So, ibahagi ko rin po ang updates ng Supreme Court pertaining to the constitutionality of RA 11479. So, for the information of everyone present or attendees in this webinar, dalawang proviso lang po sa RA 11479 ang unconstitutional. First is the qualifier to the provision section 4 of RA 11479 pertaining to which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety by a vote of 12-3. What is the reason why the Supreme Court unconstitutionalized that proviso? It is because it is overbroad. Broad ang kanyang sinasaklaw, and it is violative of freedom of expression. Second proviso is the request for designations by other jurisdictions or supranational jurisdictions may be adopted by the ATC after determination with the proposed designee meets the criteria for designation of UNCR number 1373. In other words, yung mga request ng supranational to the ATC to declare a certain individual or a group or association to be a terrorist group or terrorist individual has been considered by Supreme Court as unconstitutional. There's yet no reason provided by the Supreme Court in their ruling why it was declared unconstitutional. But the rest of the provisions of RA 11479 or the ATA of 2020 have been declared constitutional. In other words, it is within the bounds of the law and the Constitution. Aside from that, I would like to share the Ntfl CAC statements pertaining to the ruling of the Supreme Court of the constitutionality of RA 11479. So, if you can read, if you may read, it issued a press release way back December 9, 2021. So, it greatly rejoiced about the pronouncement of the Supreme Court. So they stated that this will be a victory that will ensure that the Philippines has a dynamic law at par with other countries in vanquishing terrorism, balanced with the protection of human rights. Lahat po ba nakakarinig?
Yes, ma'am. Yes, ma'am.
Clear po ba?
Yes, ma'am.
Okay. So of course, we will proceed to the salient features of ATA 2020 so that we will be aware ano yung mga violations na na-commit ng nag-patronize ng permit to win and campaign and ang nag-issue ng permits to win and campaign. Of course, ATA 2020, it was signed into law on July 3, 2020, then became effective in July 18, 2020. And then its IRR have been promulgated in October 2020, then was registered on October 16, 2020. In other words, it became fully effective on October 16, 2020. So what are the objectives of this ATA 2020? Of course, stated, first is to protect life, liberty, and property from terrorism. Second, to condemn terrorism as inimical and dangerous to national security and the people's welfare, and to make terrorism a crime against the Filipino people, against humanity, and against the law of nations. In other words, any person who commit acts of terrorism or any provisions penalized by ATA 2020, it is not only a crime against Filipino people, it is a what? A crime against law of nations. But of course, these primary objectives of ATA 2020 must coincide with the duty of the state to what? To uphold the basic rights and fundamental liberties of the people. Yung tinatawag natin na human rights. So kailangan balance ang pag-implement ng objectives ng ATA 2020 and of course the observance and respect the human rights. And of course, ATA is composed under ATA, ATC has been created. So it is composed of the following. So chairperson is the executive secretary, the vice chair is the national security advisor, and it has 7 members. So DOJ secretary, DILG, DND, DFA, DOF, DACT, and AMLC. Of course, there are also other important figures under ATC. So merong secretariat, it is the NICA and the support agencies. The ATC will not be functional without its support agencies. So usually, kasali po mga attendees ngayon sa support agencies. Then of course, what is the function of Anti-Terrorism Council? It is the what? It is the primary implementing arm of ATA 2020, and its functions are purely executive and administrative. It does not exercise judicial powers. And it adopts a comprehensive approach against terrorism. Kung inyo mapapansin, merong support agencies. Kung yung titingnan sa support agencies, halo-halo po yan. Merong participation ng DOLE, SHED, DepEd, and DSWD. So all organizations. So ano pong inyong observation yan? Bakit the ATC applies the comprehensive approach? Take note, hindi lang po laban ng law enforcement agencies ang terorismo, it is also a fight by other government agencies, including educational institutions, and labor institutions. And the ATC Project Management Center serves as main coordinating and program management arm. And of course, we will go to the law proper. Yung mga crimes related to terrorism under the ATA 2020. So, these are the crimes that are being violated by those persons who issue permits to campaign and permits to win. Mapansin po ninyo dito. So, iisa-isahin po natin yan. Also, based on Section 4, terrorism is committed by any person who within or outside the Philippines, regardless of the stage of execution, does the following. So any of the enumerated na statements either engages in acts intended to cause death or serious bodily injury to any person or endangers a person's life. Second, engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. Aside from that, engages in acts intended to cause extensive interference with damage or destruction to critical infrastructure. When you say critical infrastructure, it refers to all facilities owned by the government used for what? Providing basic necessities to the community. Aside from that, it develops, manufactures, possesses, acquires, transports, supplies, or uses weapons, explosives, or of biological, nuclear, radiological, or chemical weapons, or the release of dangerous substances or causing fire, floods, or explosions. When the purpose of such act by its nature and context is to intimidate the general public or a segment thereof, create an atmosphere or spread a message of fear to provoke or influence by intimidation the government or any of its international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or create a public emergency or seriously undermine public safety. So in other words, these are the elements of acts of terrorism based on Section 4. Any of the violent acts and any of the specific violent purpose. So to win element, violent act and violent purpose. But we need to take note that there are acts not considered as acts of terrorism. What are these? Advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights. They are not covered by terrorism. Question: can the permits to win and campaign covered under these exempted acts? No. Aside from that, there is also threat to commit terrorism. When you say threat, it is any person who shall threaten, mere threatening to commit any of the acts mentioned under Section 4 is penalized under ATA 2020. Also, the mere planning, training, preparing, and facilitating the commission of terrorism. But take note, there is a qualification on this part. There must be a what? A teaching of a skill in relating to what? To all acts of terrorism. Dapat ang itinuturo is related sa acts of terrorism. And also, there is what we call as conspiracy to commit terrorism. So any conspiracy to commit terrorism is penalized under 88/2020. So what do we mean by conspiracy? Of course, it is a basic criminal knowledge, diba? For law enforcers. When I say conspiracy, it is when two or more persons come to an agreement concerning the commission of terrorism. And, of course, they decide to commit the same. So, mere conspiracy is already penalized under 88/2020. And also, proposal to commit terrorism. When I say proposal, any person who proposes to commit terrorism to another person. Also, there is what we call as inciting to commit terrorism. They say inciting, it is any person who, without taking any direct part in the commission of terrorism, shall incite others to the execution of any of the acts specified in Section 4. By means of, take note of these, speeches, proclamations, writings, emblems, banners, or other representations tending to the same end, and is to suffer 12 years imprisonment. But take note as to inciting to commit terrorism based on the IRR, the following factors must be considered. So there must be reasonable probability that the act, speech, or expression would help ensure success in inciting the commission of terrorism. So these are the factors to be considered. Context, the speaker or the actor, how influential the speaker or the actor is, the intent, the content and form, the extent of the speech and the act, and the motive or the causation. Aside from that, the recruitment to and membership in terrorist organization. So any person who shall recruit another to participate in, join, commit, or support any terrorism or terrorist individual or any terrorist organization is already penalized under 88/2020. Also, as to membership, it must be voluntary membership. Any person who shall voluntarily and knowingly join any organization, association, or group of persons, knowing that such organization, association, or group of persons is a terrorist organization or organized for the purpose of engaging in terrorism. In other words, there is voluntariness and knowledge. Without the two elements for membership, then it will not be penalized. So for instance, those who issue permit to campaign or permit to win, is there already a presumption of knowledge? Yes. Why? They would not distribute permits if they have not read those permits they are distributing. So there's already a presumption of knowledge on their part. Also, foreign terrorists. So the following acts are unlawful and shall be punished with life imprisonment. So who are considered as foreign terrorists? First, for any person to travel or attempt to travel to a state other than his or her state of residence or nationality for the purpose of perpetrating, planning, or preparing for or participating in terrorism, or providing or receiving terrorist training. So a good example of this one is Marwan. But take note, nang pumunta sa Pilipinas si Marwan, there is yet no RA 1147/9. Ang existing pa lang na batas noon is what? The what? The Human Security Act. So there is a necessity to amend or repeal the law kasi kulang. It did not incorporate foreign terrorists present or in our country. So another categorization for foreign terrorists is for any person to organize or facilitate the travel of individuals who travel to a state other than their states of residence or nationality, knowing that such travel is for the purpose of perpetrating, planning, training, or preparing for or participating in terrorism or providing or receiving terrorist training. Also, for any person residing abroad who comes to the Philippines to participate in perpetrating, planning, training, or preparing for or participating in terrorism, or provide support for or facilitate or receive terrorist training here or in abroad. Also, this provision is the one thing that we must remember is Section 12, providing material support to terrorists. Take note, those who subscribe or patronize the permits to win and campaign is penalized under this section. So when you say providing material support to terrorists, it does not refer to money. Any material support, whether for transportation, lodging, or services, these are already included in this section. But of course, there is an exception. It excludes International Committee of Red Cross, the Philippine Red Cross, and other state-recognized impartial humanitarian partners or organizations in conformity with the international humanitarian law. And also, being an accessory is penalized under ATA 2020. So what do we mean by accessory? Is any person who having knowledge of the commission of any of the terrorist acts under Section 4 without having participated therein, takes part subsequent to its commission in any of the following manner. Either of the three. By profiting himself or assisting the offender to profit by the effects of the crime, or by concealing or destroying the body of the crime or the effects or instruments thereof in order to prevent its discovery, or by harboring, concealing, or assisting in the escape of the principal or conspirator of the terrorist acts. Take note also that the defense of relationship or affinity is not justified under ATA 2020. So, hindi magiging defense, hindi accepted na defense na kapatid ko, kaya tinulungan ko. Furnishing false evidence, forged document, or spurious evidence is penalized under ATA 2020. And also, bank officials and employees defying court authorization in relation to ATA 2020 and the Anti-Money Laundering Act will be penalized under ATA if they failed to act or they refuse to act based on a court order. And take note also that the ATA 2020 is a hybrid law. Why? Because of extraterritorial application. What do we mean by extraterritorial application? So it is any person, whatever nationality, who commits any penalized act under ATA 2020 in whatever part of the world may be subject to treaties and contrary provisions of any law of preferential application. So in other words, of terrorism or any of the provisions being penalized by ATA 2020. Kahit hindi dito ginawa sa Pilipinas, even abroad, the Philippines can charge, prosecute, and imprison those persons. But of course, Take note of this. The Philippines shall exercise jurisdiction only when such individual enters or is inside the territory of the Philippines. So now you know why we cannot exercise jurisdiction over the person of Joe Masis. And also, this law provides for major processes. So there is designation, proscription, surveillance, warrantless arrest, the precautionary whole departure order, and complaints of abuses. So iisa-isahin po natin iyan. So when you say designation and prescription, designation is executive in manner, prescription it is judicial. So say prescription, there's already a court intervention. The designation naman, it is the ATC, which is in charge of that. So for designation, it involves individuals, the groups or associations, while prescription naman, it is the subject for prescription is only for organizations. Now, the proof required. So as the designation is under ATC, then it is substantial. For prescription, then preponderance. And what are the legal implications of designation prescription? Magkaiba po yan. So sa prescription, as there is already a court intervention, it will right away issue an order to freeze the assets of the said organizations. And aside from that, the designation naman, the designee's name included in watch list submitted to AMLC for further investigation. And if designee is a UN Security Council designated, the designee shall be treated as if prescribed. So what do we mean by that? ATC lang po ang nagde-designate, so hindi right away na ma-freeze ang assets ng isang individual or group. So kailangan pa mag-investigate ng Anti-Money Laundering Council. But kung ang designee is a UN Security Council designated or nakalagay sa list ng UN Security Council, then ang effect niyan is considered na proscribed. So right away, ma-freeze ang assets ng individual or ng group. So a good example to this is the CPP-NPA. Here, the ATC designated the CPP-NPA as a terrorist group. Right now, there is a pending petition for proscription of CPP-NPA. So I am yet waiting for the decision of the prescription of CPP-NPA. So take note, there are many ways to designate a certain individual or group as terrorist. So there is what we call as motu proprio. Motu proprio, it is the ATC itself who requested for a particular individual or group's designation as a terrorist. Narinig niyo po ba yung ingay dito sa kung saan ako located? So, nasa po kasi ako sa school kasi malakas po ang internet dito na banda. Pero please bear with me, konti na lang po for the RA 1147-9. Second means to designate an individual or an organization as a terrorist is upon request of any of the government agencies or law enforcement agencies. Take note, based on the Supreme Court decision, considering the designation by a request of foreign jurisdictions, supranational jurisdictions, as unconstitutional. So what do we mean by foreign jurisdictions? Other countries would request to consider an individual as terrorist or a group as a terrorist. So unconstitutional na po. Consider ng Supreme Court. And of course, if there is already a UNSC list, the ATC will automatically adopt the said list. And for prescription, as we said earlier, there is already a court intervention. So process po dyan is NICA recommends the prescription and entity to the ATC. Then ETC issues authority to DOJ to file with the Court of Appeals for the application for prescription. Then the DOJ files with the Court of Appeals the verified application for prescription. Then it is up to the Court of Appeals whether to issue an order prescribing an entity as a terrorist group or association. Of course, there is also delisting. Ang mga list na designate as terrorist individual or group. So, usually the designee or yung nakalista sa list will file a request to ATC. Then ATC determines the grounds for delisting. And after that, ATC will issue a resolution for delisting. And also, there is also what we call a surveillance. So usually, kailangan na pong tandaan dito surveillance, the law enforcement agent or the law enforcer cannot conduct surveillance without a written authority from the ATC and the Court of Appeals approval. So usually the Court of Appeal will issue an order allowing the LEA or law enforcement agent to conduct surveillance. So take note that surveillance will only be valid for 60 days. And can it be extended? Yes. But before filing an extension to the Court of Appeals, the LEA must seek or secure a written authority from ATC. And that is the time, pag meron ng written authority from ATC, makakapag-file for extension sa Court of Appeals. Ang kailangan na pong tandaan dyan, pag meron ng approval ng surveillance, pag nag-expire na ang period for the surveillance, all the recordings must be submitted to the Court of Appeals before or within 48 hours. Aside from the recordings, meron pong sinasubmitting joint affidavit. So po, yan po yung kailangan natin tandaan sa surveillance. And also, bagong provision po ito sa inoffer ng ATA 2020, ang pag-surveillance sa TSPs and ISPs ng subject person. So what do we mean by TSPs? Is referred to telecommunication and internet service providers. So pwede po siyang i-surveillance. Of course, the same procedures na pag-record or pag-casing, profiling sa isang person or group. Kailangan pa rin mag-secure ng written authority sa ATC. And after securing the written authority, that is the time makapag-file na ng application for surveillance to the Court of Appeals. And copy furnished ang NTC. The same rule, pag ang Court of Appeals nag-approve or nag-order for the surveillance sa telecommunication service providers or internet service providers ng subject person or individual or group, it is valid for 60 days. Can it be extended? Yes, for another 30 days, of course. The same procedures, written authority for extension. For threat to commit terrorism, it is 12 years imprisonment. For planning, training, preparing, facilitating the commission of terrorism, that is life imprisonment. For conspiracy to commit terrorism, life imprisonment. For proposal to commit terrorism, it is 12 years imprisonment. For inciting to commit terrorism, it is 12 years imprisonment. For recruitment, it is life imprisonment. For membership, it is 12 years imprisonment. Also, for being a foreign terrorist, it is life imprisonment. And for those who patronize, nagbibigay ng pera for the permits to campaign and win, it is after providing material support to terrorists, it is life imprisonment. Emphasize ko lang po, life imprisonment. For accessory, it is 12 years imprisonment. Furnishing false evidence, forged document, or spurious evidence, it is 6 years imprisonment. And for bank officials and employees defying a court authorization or order, it is 4 years imprisonment. So mapapansin, malalaman po natin dito kung bakit maraming petitions na pending sa court considering the unconstitutionality of RA 1147-9. Yung kung inyong na-observe na or yung development ng ATA 2020 from being a bill until napasa siya sa pagiging batas, maraming kumukontra. Kaya dahil yan sa penalties involved sa ATA 2020. And also, for law enforcement agents or enforcers or officers, we must also take note that meron din pong naka-ascribe na penalties for removing, deleting, or expunging, shredding, or destroying any manner the tapes, discs, other storage devices, recordings, notes, memoranda, summaries, excerpts, and all copies of the recordings. Merong 10 years na imprisonment. For omitting or excluding any statement sa joint affidavit, that is 10 years imprisonment. For using recordings without court authorization or order, that is 10 years imprisonment. Unauthorized or malicious recordings o magkakandak ng surveillance without court order, that is 10 years imprisonment. Also, failure to notify the judge of the arrest of a person involved in terrorism, 10 years imprisonment. Diyan po ako kanina naputol. So take note, kung meron pong warrantless arrest pertaining to any acts of terrorism or any crimes punished under ATA 2020, we have to do 3 things. First, to notify within 24 hours the ATC na meron tayong naaresto. related sa terrorism. Aside from that, we need to inform the court na merong jurisdiction kung saan natin na-aresto within 48 hours. And the CHR. Failure to notify the judge, merong corresponding na penalty, that is 10 years imprisonment. Aside from that, violation of the rights of a detainee, 10 years imprisonment. Failure to comply with the requirement of an official logbook, 10 years imprisonment. So this official logbook is only exclusive for all the crimes committed in relation to 88-2020. For committing torture, at least 10 years imprisonment to life imprisonment. For malicious examination of a bank or financial institution, 4 years imprisonment. And unauthorized revelation of classified materials, violating the confidentiality of the documents, that is 10 years imprisonment. For infidelity in the custody of detained persons, 10 years imprisonment. And furnishing false evidence, forged document or spurious evidence, that is 6 years imprisonment. So it's for law enforcers or law enforcement agents or officers, meron po tayong tinatawag na threefold liability. May criminal liability, may administrative liability. Sa administrative liability, right away po penalty of dismissal. Aside from that, may accessory penalties of what? Cancellation of civil service eligibility, forfeiture of retirement benefits, and perpetual absolute disqualification from running for any elective or holding any public office. Third liability is civil, pertaining to damages. So kailangan po tayo na law enforcers na nag-i-implement sa provisions ng 88-2020, aware and knowledgeable sa batas na ito. Kasi meron kaakibat na threefold liabilities against us. So that ends the presentation of the PNP. Row 8 po.
This is Channels. We listen, we tell, we inspire. This is